Justice Clement is not participating in the next case, therefore I'll be presiding as the senior member of the court. We call the case of Heos versus City of East Lansing. Appellant ready to proceed?
Good morning, Your Honors. My name is Greg Hanley of the Kickham Hanley firm. I'm here today with two of my colleagues, Jamie Worrow and Ed Kickham Jr., and our co-counsel, Andrew Abood of the Abood firm. We're very pleased to be here and be able to present our arguments. Headley is a constitutional amendment that forces local governments to make a simple but sometimes difficult choice, and that is to either finance their activities out of their existing revenue streams or go to the voters and ask for more revenues in the form of taxation. This court has recognized that municipalities sometimes have an incentive to evade those constitutional limitations by characterizing what are really disguised taxes as fees or permits or licenses. The Headley limitations are intended, and they're reflected in the Bolt's decision, to prevent that kind of cheating. And this city has been found by the circuit court to have cheated by creating a very creative method of municipal finance that involved deputizing a utility that provides an essential service to collect and remit a franchise fee, a so-called franchise fee, that the city admits it could not impose directly. The Court of Appeals did not disturb the finding that this was a tax that violated Headley. Instead, the Court of Appeals decided the case on statute of limitations grounds. But while nominally based on statute of limitations grounds, it's really a case about standing, because it turns on who is the taxpayer, right? Because under the Headley statute of limitations, if you're just an interloper, a member of the public, you know, somebody from Warren could challenge a tax in Lansing. You're relying upon your standing as a member of the community.
Counsel, good morning, and thank you for coming with us today. The question I have is, how do you define taxpayer, and what role does the taxpayer play in this entire scenario?
Well, there is a distinction between what is sometimes called taxpayer standing, which is a standing that Headley gives to any member of the public, regardless of whether they've paid the fee at issue. But when we talk about taxpayer in this context, we're talking about who bears the legal incidence of this charge, okay? And so if you bear the legal incidence of it, you are the payer of it, and you have standing basis on the basis of your payment of the actual tax. And therefore, the notion that the statute starts running when the resolution or the ordinance is enacted falls away, because you have been subject to and paid the tax at issue. So in the Court of Appeals view, it was important to decide, is it the LBWL who's paying this, legally paying this, or is it the end users and the citizens, the thousands of citizens of East Lansing? And what the Court of Appeals did is basically authorize taxation by contract, which is a clear violation of Headley. But what's at issue here, the principal question raised in this appeal, or this application, is who's the taxpayer? Because if it's the end user who's legally responsible to pay this, then the statute of limitations analysis conducted by the Court of Appeals has to be vacated, because it's a total, the taxpayer's allied case says the only type of claim that would be subject to the, that would start running when a resolution or ordinance is passed, is a claim brought merely on behalf of the public, as opposed to brought by somebody who is subject to or about to be subject to the tax. So that distinction has to be made. Who's the taxpayer? And I would suggest to you that the answer lies within the four corners of the franchise agreement that ultimately became an ordinance of the city binding on everybody. There's been a lot of questions raised that we've raised throughout this process. We've had 5 briefs. And we've repeatedly talked about the actual provisions of the franchise agreement. which were ignored by the Court of Appeals and haven't been addressed by the city. For example, if the franchise fees are legally imposed on the Board of Water and Light, such that the Board of Water and Light has the absolute obligation to pay the franchise fees, why was there a need to change the critical provision in the draft franchise agreement from one requiring the LBWL to pay the franchise fees to one requiring the LBWL to merely collect and remit the franchise fees to the city? Collect and remit, as we've seen in the cases, are magical kind of talismanic words. And what it means is it's relieving the collector from the responsibility. And this court in the World Book case had a situation where the use tax. In Michigan, the sales tax is imposed on the retailer, and they're entitled to recoup it, okay? The use tax is imposed on the end user, but you can deputize somebody to collect that. And in World Book, there was a statute requiring the bookseller, in this case, to collect the use tax from people in the state of Michigan and remit it to the government. And the Department of Treasury sued World Book saying, you didn't give us all the money. You have to pay it. If they didn't pay you, you have to pay it. And this court said, no, the collect and remit language means that they have a reasonable duty to do what the statute requires, but they're not the guarantor. They're not the taxpayer, okay? So
if they just drafted this a little differently, then would it have been fine? If they'd chosen some different words?
Well, they would have had to choose completely different words.
Because, I mean, I know the Court of Appeals relied on Morgan, which I found pretty analogous. And I know there's efforts to sort of parse it apart, but why isn't this just Morgan?
Because Morgan involved a federal statute under the Cable Act that expressly authorized a franchise fee, but made very clear that the franchise fee is imposed on the cable utility, and that they were allowed to pass it through. That is a far cry, and that's why the provisions of the franchise agreement, which became force of law through an ordinance, have many other provisions which make clear that this is not the LBWL's responsibility. For example, why was there a need for a franchise agreement to include a provision requiring the city to, at all times, keep and save the Board of Water and Light harmless from and against all loss, costs, expense, and claims associated with the collection of this franchise fee? Okay? Why is the LBWL precluded, excused from remitting the fees if they're precluded from collecting such franchise fees from its customers in the city? That's a provision too, okay? And if the franchise fees were imposed on the LBWL, why was the LBWL required by the franchise agreement to include the franchise fee as a separate line item on the LBWL's bills to its customers? That was a critical part of Morgan, Justice Welch, is they said it was not the city's requirement that it be on the bill, it was Comcast. And here, it's the city's requirement put into the ordinance that it be a line item on the bill, okay? Which again, in all of the cases, they talk about that as dispositive indicia of legal incidents, okay? So
did Morgan do any sort of supremacy analysis in the opinion?
I'm sorry?
Did Morgan do any sort of supremacy analysis in the opinion? You said Morgan is different. There was a federal statute that authorized this.
No, I don't think I wouldn't say it was a supremacy thing. It was that the federal statute made clear who bore the legal incidents. It wasn't, in all cases, the first question is, who bears the legal incidents?
And it was the cable company.
It was a cable company. And the federal statute expressly says, gives them the authority to impose it on the cable company, okay? There's no words to that effect in this ordinance. And in fact, the city in the franchise agreement agreed to pay the Board of Water and Light a fee for collecting the franchise fees. So how nonsensical would it be to pay?
So really what you're saying, Morgan says that the fee went to the company. We're here, The company is just a conduit to give the money back to the
Right.
city.
Right. And Michigan law recognizes this.
And when it goes back to the city, it becomes a tax. And now Headley becomes involved.
Right, that's exactly right. And what this court said a long time ago in Lockwood, and it's been cited several times since then, is one may be charged with the duty of collecting a tax on behalf of the government, although the ultimate burden of such tax does not rest on him. That's what the use tax statute does for retailers. It says you are to collect and remit. And there's a federal court case we cite, not because it's controlling, but because it states concisely this principle. And this is the Coeur d'Alene tribe versus Hammond case from the federal court out in Iowa. A party does not bear the legal incidence of the tax if it is merely a transmittal agent for the state tax collector. Under such a collect and remit scheme, the state enlists one party in a commercial transaction to collect the tax from the other party. That's exactly what has been done here. In very creative way, but it results in, and here's the real unfairness of it, is they weren't paying this franchise fee, or they didn't agree to pay this franchise fee to obtain the use of the city's right-of-ways. They already had that for free, and they had a perpetual right under the Foot Act, right? But what Section 7 of the franchise agreement makes clear is that they paid that to get an exclusive territory. In other words, we're going to pay this to you in exchange for an exclusive territory. And either of the parties could have at any time terminated that exclusive territory. And as such, either party may terminate the exclusive right to serve upon 60 days prior written notice. Therefore, to the extent either shall cease, the exclusive territory or the payment of the franchise fees, both ceases. So what?
I'm not trying to cut you off or boot you from the podium. I don't recall if you asked for time to rebut, but you're under 3 minutes right now.
I'm under 3 minutes? Okay, I'll reserve the rest of my time.
Okay, let's hear from the appellee.
Thank you. Good morning, Your Honors. Laura Genovich on behalf of the City of East Lansing. I want to start with Justice Bernstein's question about defining a taxpayer and say first, of course, the city disputes that this is a tax at all, but just to use the phrase taxpayer in the way the court has used it in its MOA order, it's the person or entity who is ultimately legally liable for the charge. And here, that is the Board of Water and Light. There is a contract memorialized in an ordinance that requires the Board of Water and Light to pay the franchise fee to the city based on its gross revenues. There is nothing in the ordinance that creates any legal obligation on the part of plaintiff or any other customer directly to the city. The city cannot sue plaintiff or the other customers if they don't pay. The city cannot place a lien on their property. The city cannot turn off their electric service. The city does not provide electricity to the customers. The city cannot direct the Board of Water and Light to turn off their electricity. There is no recourse that the city has against plaintiff or the Board of Water and Light customers. And so that's kind of the overarching answer
But
to a lot.
isn't the problem, though, that it also appears from the language of the franchise agreement that the city doesn't have any recourse against Board of Water and Light either? They don't, there's no obligation to remit the fees if they don't collect them from the citizens of East Lansing. They're precluded from collecting this fee. The city can't get it from Board of Water and Light if they can't get it from them, and they have to hold them harmless. So while the city, I get your argument that the city can't go against the utility users, doesn't look like the city can go against Lansing Board of Water and Light either.
I respectfully disagree. There's a couple of options. One, under Section 7, the city could take away the exclusivity provision that Brother Counsel was just referencing, but it also could terminate the franchise agreement. Regardless of the Foot Act arguments, which are kind of a separate issue, and that's, I think, extensively brief that plaintiff doesn't have standing to bring a Foot Act claim, and the parties, the Board of Water and Light certainly can voluntarily enter into a franchise agreement. Foot Act would deal with whether that can be forced upon them. Setting that aside, this is still revocable, so there would be a consequence if Board of Water and Light did not pay that money.
There's a consequence, but they can't collect the franchise fee if Board of Water and Light doesn't give it to them.
Well, I think the distinction is if the Board of Water and Light doesn't give it to them versus if the Board of Water and Light were precluded from collecting it. And that distinction would be if the Board of Water and Light did charge its customers to recoup that cost and then did not pay it to the City of East Lansing, I think the City of East Lansing would have a breach of contract action against the Board of Water and Light. Despite the way Brother Counsel has kind of narrated in the brief, it's not a matter of, well, if one taxpayer doesn't collect it, then it doesn't get turned over. The language is more that if the Board of Water and Light is precluded from collecting it, which I think speaks to this court's second question in the MOA, which is that plaintiffs can bring an action against the Board of Water and Light. If they believe that that 5% charge on their bill does not relate to the service they are provided, that it's disproportionate or not reasonable or otherwise unlawful, then plaintiff and other Board of Water and Light customers can sue Board of Water and Light. There's simply nothing stopping that. And the availability of that remedy further shows that the Board of Water and Light customers are not the direct payers, going to, of course, kind of the crux of the case here. And I think, Justice Welch, you're right, that Morgan is analogous, and we see the exact same thing in cable franchise fees. I think that counsel overstates the federal statute.
But the federal statute clearly provided that it goes to the company. It does not go to the municipality. And here, it's going to the municipality. And I'm troubled by email sent by Lansing Board of Water and Light. It seems to suggest that they knew it was a franchise fee and was in fact an illegal tax, and altered the agreement to make sure it had no legal responsibility to pay the fees beyond the amount that it collected from its consumers.
Sure, I have a couple responses to that. First, the language of the federal statute, as quoted on page 18 of plaintiff's supplemental brief, is simply that payment under the terms of franchise, subject to the limitation of subsection B, any cable operator may be required under the terms of any franchise to pay a franchise fee. That doesn't speak to legal incidence of the tax or passing it along, or it doesn't say quite as much as I think it has been suggested that it says. So I maintain that Morgan is on point. But going just...
I'm kind of missing that, though. If it says that the cable provider can do it, it's going to the cable provider. It's not then turning around and giving it to the municipality that permits the cable provider to operate.
Respectfully, Justice Zara, this statute is referring to the cable operator paying the municipality a franchise fee.
That's the federal statute?
Correct.
Okay.
And there's nothing precluding a franchise fee. The amicus brief filed by the Michigan Municipal League does an excellent treatment of the long history of franchises and franchise fees. It's not a scheme. They're perfectly lawful and an important part of franchise history in Michigan. The federal statute applies to cable, but franchise fees are lawful, and plaintiff in their brief does not dispute that. They take issue with this particular fee, but franchise fees...
Their position is this isn't, in fact, a franchise fee, right? It's not
Certainly.
a legitimate, I mean, that's their contention. And that's where I'm sort of, like, this question of statute of limitations versus whether or not it actually violates Headley. If we were to find that the Court of Appeals was incorrect, and that, at least as alleged, that they have alleged a claim that can at least proceed, does that necessarily decide that this is in fact a tax, or does that still, it has
Not
to go
at all.
back? Okay.
Respectfully, not at all. The circuit court addressed the merits because it found the claim was not time barred, so the circuit court reached the merits. The Court of Appeals found it was time barred, so did not reach the merits. So the merits of the Headley claim, and I won't argue that today, but there's of course we would say, very strong arguments that it is not a tax applying the Bolt versus Lansing analysis. But that's not before the case, or that's not before the court yet. So that would still separately have to be decided. But I want to make sure I address two things. First is kind of the collection agent theory that plaintiff has proposed. And the problem with that analogy is that to be a collection agent, there has to be a principal and a debtor. There has to be an obligation directly between, would be the customer and the city. For example, if plaintiff owed sewer fees directly to the city for sewer service that the city provided, and plaintiff did not pay those sewer fees, then the city could hire a collection agency to go out and collect that debt. That analogy doesn't track here, where there is, again, no direct liability on the part of the customer to the city. There's a voluntary agreement between the Board of Water and Light and the city. There is a separate agreement between plaintiff and the Board of Water and Light when they decide to get electric service from there and agree to pay those charges. And that is the distinction. In terms of just kind of
Why then does the franchise agreement say that the city pays Board of Water and Light a fee? The city is paying
Sure.
Board of Water and Light for them to collect this fee that you say belongs
Sure.
to the tax, that Board of Water and Light is the taxpayer.
Sure. Well, two responses to that. First, it simply doesn't change. It's something that the parties negotiated. I don't think we looked to the emails necessarily because the ordinance is unambiguous, presumed valid, and we looked to that. But there's nothing about the negotiation of that fee that creates a legal liability on the part of plaintiff to pay that charge. And secondly, the Board of Water and Light also charges its customers a late fee on these that it doesn't remit to the city. So, and that's in Appellant's Exhibit E in the supplemental brief with the Board of Water and Light's terms of service. They certainly treat it like their own income revenue when they are charging a late fee. So it is not a legally significant fact that that is there when we look at who is actually liable for paying this. And the problem with plaintiff's test, plaintiff really takes the step relying on some federal case law that I think has no application, and I wouldn't necessarily have time for all of that, but look at the amicus brief by the MML where it talks about why the federal cases involving intergovernmental tax immunity are really not on point. Regardless, where plaintiff gets with that is that any time you have a pass-through charge, so anytime a municipality charges a business or utility a charge or a fee of some kind, and that is passed on to the end user, that end user becomes a taxpayer of the city. That would eviscerate Headley. Every cable franchise, every Metro Act for fiber optic internet where there are fees that get routed back to the municipality, those are paid. You know those are paid, they're on the bills. Any business or utility that's working with the city and getting charged is passing on those costs to its customers.
But that's the whole point of this contention, right? Like that is permissible. That's what Morgan said is permissible because of the way it's structured. Their argument, at least as alleged, and maybe they're not able to eventually prove it or prove that it's a tax violative of Headley, is that this is different. This isn't like those kind of fees, and that's why it's not permissible.
It's factually identical to Morgan. It was a line item on the bill. The customer paid it to the cable company paid it to the city of Grand Rapids. The only distinction plaintiff has ever drawn from Morgan is that federal statute that again just says, yes, cable companies can be required to pay franchise fees. Well, guess what? Boards of Water and Light can be required to pay franchise fees too. That's not unlawful.
But didn't the federal statute do more? Did it not also authorize that the cable provider pass the charge on to the consumer?
What Morgan noted was that it contemplated it being a line item on the bill. But what Morgan said was it doesn't matter whether it's a line item or not a line item. It is still the cable provider, here we would say the Board of Water and Light's legal obligation to pay it. Or more importantly, it's not the end customer. And where it goes back to, of course, is what is the wrong that is triggering that 1 year statute of limitation? What is the defendant's wrong that starts the clock? If you are a direct payer, if you are paying a sewer fee to the city or another direct charge that you claim as a tax, you know that 1 year under this court's case law and Court of Appeals case law starts to run when you get your bill, right? When you get assessed. But here the only action the city ever took was in 2017. Okay. And that's what Morgan held as well. You can't start that clock from when a non-city entity sends a bill to the end user.
What about somebody who wasn't even a resident or a user of Board of Water and Light within a year of 2017?
Then they
So
could
they just move into the city in 2020 and all of a sudden they're getting this, they're out of luck?
No, they would have an action against the Board of Water and Light, the entity with whom they have contracted and who is charging them. The city is not sending them a bill. The city is not charging them. Frankly, from the city's perspective, it doesn't know which customers are
So
paying
they
or
could sue
not.
Board of Water and Light, but you would agree that they don't have any right of action against the city?
They would be time barred on a claim against the city, correct,
Okay.
because they are not a direct payer of the tax.
Okay.
And counsel, so if we were to agree with plaintiff's position, is it your position that that would basically open the floodgates and that all these franchise fees would be jeopardized?
Exactly, all franchises, even more than that. I mean, think about the costs, perhaps not as transparently. I think frankly, the governmental parties here were very transparent in this. As Justice Wells, you indicated earlier, well, what if it had been written differently? We know the same customers were still going to be, paying that cost ultimately to the Board of Water and Light so that it doesn't, so that it doesn't take it out of profit or somewhere else. We know that businesses or utilities pass on those costs down. So, you own property and the city charges you a business license fee, and then your costs go up down below, or you're a property owner renting it out, and you pass the cost of your property taxes
But
down.
that's only if they're successful in proving that they're a violation of the Headley Amendment.
Certainly, but we have to cross this threshold before we even get to Headley. And of course, we take issue with the suggestion that the Court of Appeals reach statute of limitations in a way to opine on the merits. The Court of Appeals did not reach the merits because it found under Morgan, which we believe is not only, I would still say identically, factually, but consistent with this court's decision in the footnote 7 in Tact versus Wayne County, that if you're not the direct payer, your statute of limitations accrues when your defendant, the city, took its action. And again, here that was in 2017 with the enactment of the ordinance.
Yeah, I'm sorry to ask again, but I just didn't quite get the answer, or it didn't soak into me. But please help me understand why the federal act permitting a 5% franchise fee to be passed on to the consumer isn't pertinent in this case. Why is that fact in Morgan? Why doesn't that fact make Morgan very distinguishable from this case, where there's nothing that permits that to be passed on to the consumer other than the agreement of parties?
Federal law, plaintiff would say, would make it permissive or make it permissible for there to be a franchise fee on a cable company that's passed along. There's nothing prohibiting the City of East Lansing and the Board of Water and Light from agreeing to a franchise fee. I think that's undisputed. It's not an.
But they would say it's Headley that.
Other than, but setting aside Headley, but just a franchise fee in itself. And under Morgan, there's nothing wrong with a line item. There was a line item, and the court said it wouldn't have, it wasn't dispositive that the federal statute provided for that line item. That's not what Morgan decided the case on.
Counsel, could there be a case where a franchise fee could be a disguised tax?
I think that again gets into the merits. So if you had Board of Water and Light arguing, let me back up and say this was an agreement, right? Board of Water and Light and the city clearly negotiated it. If you had a city somewhere, just unilaterally imposing a franchise fee on a utility, that utility could argue perhaps it's not related to its use of the rights of ways or things like that. Here it clearly is on this record related to the cost of the rights of way. That still would not extend down to end-use customers of the utility. It would be
The utility would have the
utility's
claim.
Headley claim against the city.
Thank you.
I see my time is up, so if there's no other questions, thank you.
I think it's really important here to remember that agency law plays a role here. As Justice Zara pointed out, while they were negotiating this, the general manager of the LBWL is saying, should the board choose to go forward with the franchise fee, the BWL would only be the collection agency for East Lansing. And after that, the agreement was very carefully structured to remove any legal responsibility from the Board of Water and Light. Give us what you collect, you're not liable for anything more, blah, blah, blah. If you go to Morgan, Morgan had a clear responsibility to pay it regardless. If the cable company couldn't collect that franchise fee from its end users, it still had the responsibility to the government to pay it. That's a completely different situation than we have here. And in Morgan, plaintiff pointed to the moment she received her bill as the moment of initiation. But the inclusion of the charge on the bill was Comcast's action, not defendants. Similarly, so here, the ordinance, which incorporates a franchise agreement, expressly says this fee shall appear as a line item on your bill. Shall appear. It was dictated by the city, okay? And its citizens who are bound by that ordinance are bound by that line that says it's going to be a line item and payable by the end user, okay? So if you look at all the state law, which we cited, but under federal law, this comes up a lot, because the federal government is exempt from state taxation. And so it's often, the federal courts are often called upon to determine, does the federal government, as the end user of a service, bear the legal incidence, or is it a retailer or a distributor or whatever? And what the Supreme Court has said repeatedly is that a mandatory pass-through provision is, quote, dispositive language of legal incidence. In other words, if it's required to be passed through, not allowed or permissive, it's dispositive of the issue of legal incidence. And I'd refer you to the U.S. versus Delaware case, which is very similar to what's going on here. Dover Air Base in that U.S. v. Delaware case was incurred a tax from a utility provider. And the question was, did the government bear the legal incidence, or was it borne by the utility provider? And they said, for the same reasons that this is a tax on the end user here, it was a tax on the government there. Because the government required that a sales tax passed on to the purchaser and be collected by the vendor from him, this establishes as a matter of law that the legal incidence of the tax falls upon the purchaser. And so, under Michigan law, this isn't a three-party transaction. This is a two-party transaction, because the LBWL is the agent, which they wanted and got in this agreement, and
No more
as
ands,
agent,
no more ands. Your time's almost up. You got 5 seconds to wrap it up.
they're the same legal identity once they're deemed to be agent. And they were very careful and had, LBL had great lawyers.
Three
They
more
had great
ands.
lawyers.
The arguments were very good, very helpful. The case will be submitted. Thank you so much.
Yeah.